Hi, everyone. My name is Rachel Marks, and I am the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Jessica Murphy, a Massachusetts construction lien law guru. Today's webinar topic is, what happens after I record my lien? How do I get paid? So without further ado, I'd like to introduce the fabulous Jessica Murphy.
Oh, thank you, Rachel. I appreciate that. It's always great to be here, and thanks for having me back. And you'll learn a little bit here about what happens after you do a mechanics lien and how do you actually translate that into dollars, which I know is the key here. So we can start with the first slide.
Okay, so really quick, if anyone has any questions, just go ahead and use the GoToWebinar chat box on the right, and we will answer the questions at the end. Please make sure not to include any names or company names in your questions. Okay.
Great. So Massachusetts mechanics liens. What is a lien? Who can pursue a lien, and how do you do it? So this is just the basics here. A mechanics lien is a lien against private property where labor is performed or materials are provided. And it basically operates a little bit like, if you think about it, a mortgage. It attaches to a property, and it's a really interesting thing because it's created by statute. And in Massachusetts, you obtain a mechanics lien by filing with the Registry of Deeds. So it's a unique type of remedy to get people in construction paid. General contractors, subcontractors of any tier, and suppliers can all pursue a lien. It applies to any different types of trades out there, construction management services, landscape architect, if you do rental equipment, site surveyors, land surveyors. Essentially, if you've participated in improving real property, that's all that's required in order for you to have a mechanics lien. Although less common, there are liens just for labor. If you are not only a service provider, but you have man or women power on the job, labor liens are permitted as well. So those are under Section 1. I won't get into those in as much detail here, just because those are a little bit less common. Real quickly, for labor liens, you could get the value of labor over a 30-day period that's been provided in the 90 days before you file. That's different than the other types of more common liens we'll talk about. So on the next slide, just goes through real quickly the benefits of the mechanics lien. Because this is done by statute, an important thing to know too is that every state is different. This is specific to Massachusetts mechanics lien law. It is created by statute, so you need to, it's relief you wouldn't otherwise have as a subcontractor or supplier, because typically if you're a subcontractor or supplier, your contract is with somebody else in the chain. The mechanics lien actually gives you rights directly against the owner and the property. What it gives you, the most important thing, is that if you can't reach a resolution and get your lien paid, a judgment in your favor at the end of the day pursuing your mechanics lien will get an order to sell the property in order to pay lien holders, which is an incredibly powerful tool. So this is significant leverage to get payment from the owner. So moving on to the next slide, how do you actually pursue the mechanics liens as a general contractor or subcontractor? First thing you're going to do is make sure that you have the Massachusetts requirements for a lien, which is that there is a written agreement that is very broadly defined, but there needs to be something in writing with some form of an acknowledgement by the party that you're working with. You need to have services, either labor or providing of materials, done to benefit a private property. Mechanics liens are not permitted on public land. And you're also going to need to know where the property is and obtain a deed reference. With that information, that's when you're going to call SunRay. So, and I've worked with SunRay for a while. They're going to take care of preparing the first document in Massachusetts, which is the notice of contract. The next document in Massachusetts is a statement of account, and then thereafter you need to file a verified complaint with the court in order to perfect your mechanics lien. The timing here that you can see on this slide talks about the notice of contract needs to be recorded within 90 days of the last date that any contractor under the general contractor has performed work on the job. And so I like to think about this as the umbrella theory. If a general contractor is holding an umbrella, who's going to fall under that umbrella? Now, if the owner goes and separately contracts for other work, that person isn't included under the general contractor's umbrella. But anybody in a typical construction project that's going to flow from the owner to the general contractor is going to hire their subs, there's going to be suppliers. Anybody within that umbrella, that chain, is going to be able to use the last date of work for anyone who's done work under that prime contract in order to, for the timelines here. So 90 days to record your notice of contract, 120 days to record your statement of account, and then filing the verified complaint 90 days later. Usually at the verified complaint stage is where you'd go get counsel involved because that needs to be done in the local court. So on the next slide, the only difference we're pointing out here is that if you are a lower tier contractor, which is you are a sub or below, you're going to look at wanting to send a notice of identification. That's a statutory form. And basically what it does is it gives the general contractor notice that you're out there because you don't have a direct contract with them as a second tier sub or below. And they may not know that you exist. So to give them fair notice and to make sure your lien has the maximum value, you're going to be required to send this notice of identification. If you don't, you can still have a mechanics lien, but the value of your lien can be limited to the amount that's due from the general contractor to the contractor above you. To maximize the value of a mechanics lien, I do recommend doing a notice of identification if you're not the party with a direct contract with the general contractor. This idea of notice of identification is a little confusing, so always happy to take any questions on that if anyone has them. So on the next slide, what's required next once this mechanics lien is filed is litigation. So there's a complaint that's filed in the Superior or District Court in Massachusetts. Superior Court in Massachusetts are all claims that are above $50,000. District Court handles everything below that. And we would expect at the time that you're going to take your lien and continue to perfect it by filing suit, that you're going to include all the other claims against any other party related to the same matter. So typically we find that our complaint is going to be against the owner with the mechanics lien claim, against the general contractor who you may have the contract, if that's the party that you're contracting with, or if you are a supplier or lower tier subcontractor, the party that you have your direct contract with, there would be a claim against them for breach of contract for failing to pay. If you have a credit app and you've taken a guarantee of the debt, then you're going to include your claim against the guarantor there as well. Timing is really important on these things. I know that the key here is getting you paid. If you need to pursue litigation and things don't resolve promptly, then you're going to find that in a Superior Court case, this type of case is on what the court calls a fast track, which means that from the filing of the suit until your final pretrial conference, which is where your trial date is assigned, is going to be approximately 16 months. It may run quicker, but if the other side, the defense, takes time and doesn't push it along, which a lot of defendants do, then you're going to be about 16 months, so about just under a year and a half to get from initiation and filing of the complaint to a assignment of a trial date. In district court, where you have cases below $50,000, there is no pre-scheduled case deadlines and timing like this. The case in district court will move as quickly as the parties move it, which is, I think, a benefit. You must prevail on the merits of your case in order to recover on your mechanics lien. So you must be able to prove that you're due money and there are no defenses, such as payment. If the owner has already paid the general contractor at the time that you have filed your mechanics lien, the time that notice of contract is first recorded, then that will limit the value of your lien. The owner once a mechanics lien has been put on by that first recording of a notice of contract, isn't required to pay twice. So if they pay in full before you place your mechanics lien and file that first document, then that's going to limit the lien. So the key here is to get your mechanics liens filed early. You can file a notice of contract anytime in Massachusetts once you have an executed contract, up until 90 days after the last work on that project. So going to the next slide. Best practices for success in litigation. So this is going to be something that's really going to be impactful for getting you paid on a mechanics lien claim, but also applies to any other litigation that you may be part of. First thing you want to do is make sure that your agreements with your customer are documented, both the original, perhaps a credit agreement or a general agreement on how you're going to provide services or materials, which have credit terms, which have interest rates, which have days to pay, and preferably your agreement that they will pay your attorney's fees. Have those documents in writing. Make sure you document change orders. Make sure you document additions and modifications to the contract. Keep legible, complete copies of the paperwork. If there's a purchase order, make sure you retain both sides. Having this information handy is going to help you succeed in the mechanics lien case. Another important thing if you are a supplier is that you keep copies of delivery slips. A lot of times people will dispute that the materials actually made it to the job. It is the lien, the person, trying to enforce the lien. It is their obligation to prove that the materials went to the job site and were incorporated in that project. Typically, your invoice or delivery slip will be good enough. Obviously, if you have that signed, it's going to be much more powerful. The other thing you want to do is analyze the potential counterclaims. Anytime there's a non-payment, I expect that there's going to be a performance counterclaim or defense that's going to be raised. Assess those things early on. Try to identify if there are going to be the claims and if there's any merit to them. I also would suggest for best practices for success that you probably pursue collections. So that would include things like sending out demand letters, sending out statements, making sure you're not holding your invoices. You want to make sure, of course, that you're going to get your claim in within the appropriate statute of limitations. And for, again, mechanics liens, you've got that quick turnaround of that 90 days. So you want to make sure that you're acting promptly so you can get your mechanics lien recorded, but also that you're acting promptly so you don't miss any other statute of limitations, which is the time by which you must file claims just generally. So you've got, of course, years to file it on the other side for negligence claims and breach of contract claims. So you want to be acting quickly so you don't run into those problems. Also, if you delayed in pursuing your claim and there was a defense that they could have mitigated had you told them sooner, that could be a defense and reduce the amount of recovery you might have. Also in construction, people tend to move jobs. There's been a lot of migration in the workforce recently. So if you're pursuing these quickly, it's more likely that the employees who know about these projects, who were there and can attest that things were delivered, are going to still be working for you, and that these things are going to be fresh in their mind. Last thing is to keep your eyes and ears open for information about customers' work. This is a huge one in any litigation, but in mechanics liens as well. You want to know what's going on with your client. Have they been paid? Because again, going back to the requirements of a mechanics lien, you can have a mechanics lien only up to the value that the person above you has not been paid for. So if you're a subcontractor and you have a contract with the general, then when you file your mechanics lien, if the general contractor is owed $50,000 on the project, and it doesn't matter if it's related to your work or not, then what would happen is that they would, if your mechanics lien was for $60,000, your mechanics lien is going to be limited to $50,000 because that's the only amount due or to become due between the owner and the general contractor at the time you file. So the sooner in the project you record your notice of contract, the greater likelihood is that the owner has not paid in full and that money has not trickled down. So you want to record those notices of contract early to make sure that defense isn't there. But you also want to ask, hey, have you guys been paid? If you know that they've been paid, it may make your decision that you don't want to pursue a mechanics lien. You can weigh that information if you find it credible. The nice thing about mechanics liens is that these are very powerful tools. Contractors, general contractors are typically required by the owner to clear the liens as part of the owner-general contract. So the general contractor will typically get involved right away. The owner does not want their property liened. It can impact construction financing. Obviously, at the end of the day, if they lose the mechanics lien case, the property is ordered to be sold to fund the debt. And so there's a lot of reasons why these are dealt with very promptly. So if you have your mechanics lien, I will tell you that there is a large likelihood that somebody is going to reach out before the litigation goes too far to try to reach a resolution. When I represent owners and general contractors trying to resolve other parties' mechanics liens, if the debt is valid and there's proof that the materials were provided, even if there's an intermediary subcontractor who's gone out of business or doesn't have the money to pay, then an owner or general contractor is going to step up because they know about the power of a mechanics lien, and they know that that's going to have an impact on the property and potentially require it to be sold. So they're very powerful, and a lot of times they will go ahead and get resolved early on. In my 18 years as a construction litigator, I have only had 2 mechanics lien cases that will go to a judgment and order the property sold. One last quick point to make is that there is a potential that a lien bond will be recorded to clear the mechanics lien off the property. That's actually a great move for anybody looking to get paid because a bond is backed up by a surety company and they're going to be paying out cash rather than having to go through the sale process of the property if you get a judgment. I know we started a few minutes late and I do want to wrap up on time, so I'll leave that for questions, and hopefully I've been able to impart a little bit of information and something that you didn't know or clarified something that you were interested about in the talk so far.
Jessica, thank you so much for your time this morning. You really did just such an incredible webinar, tons of valuable information. Thank you again. We appreciate your time as always. And, I don't see any questions that have come in just yet, but if anyone does think of a question, after the webinar, feel free to reach out to myself or Jessica so that we can make sure to answer any questions that you may have. Let's see here. If you guys want to take a moment to review us on Google, you can do that. And I wanted to go over the next 2 webinars that we have with Jessica. So you guys can go ahead and register at sunraynotice.com/education. The next webinar will be on July 12th from 9 to 9:20 a.m. Eastern Standard Time. And the topic is don't sign a release unless it passes this checklist. And then the next webinar will be on Wednesday, October 11th from 9 a.m. to 9:20 a.m. And the title is Getting Paid Faster with Liens, Bonds, and Contracts. And that's all that we have for you guys today. So once again, Jessica, thank you so much. Thank you to everyone who joined us, and we look forward to our next webinar with Jessica. Thanks so much and have a sunny day.
Thanks, Rachel. Take care, everybody. Bye-bye.